According to historians and anthropologists, the original inhabitants of India are the people who we know today as the tribal people. The scheduled tribes were initially included in the people known prior to independence as the depressed classes. However, in independent India, they have been categorized separately from the scheduled castes. They constitute about 7.5% of the population of India. However, this is a misleading way of looking at it, because though it seems to be a small fraction of the total populace, it is in reality a huge number, and the number of Bhils, Santals and Gonds who are classified as tribes would outnumber several independent nations many times over. As an official grouping, the scheduled tribes are defined as those who are declared to be so by presidential order under Article 342 of the Constitution. Such an order, containing the list of all scheduled tribes, has to be issued for every state and union territory. It is also to be noted that the scheduled tribes have traditionally resided in areas that are not easily accessible to urbanization and have thus been able to maintain their own distinct culture and distinct practices. Unfortunately, this has also meant that they have been deprived of several social utilities and benefits and have not been able to access the benefits of education and development at the same pace as the rest of the society. This disability has been reinforced by the caste system and the practice of untouchability, which extends to the members of the scheduled tribes also. Just as the scheduled castes, they too were excluded from education, access to wells, temples, etc. There was similar taboo in interactions with the scheduled tribes as there was with the scheduled castes. At the time of the framing of the Constitution, the question of the scheduled tribes was dealt with great caution, and much attention was given to the intricacies of the issue, and several special provisions were created so as to safeguard the interests of the scheduled tribes. This, in some cases, goes on to the extent of changing the basic system of governance. The concern which the founding fathers had in mind is well reflected in the goals laid down for the country in the preamble to the Constitution, which seeks to ensure social, economic and political justice for all. Fundamental rights are the lifeblood of the Constitution, and the rights conferred therein are probably the most important conferment on any citizen, especially in the case of the scheduled tribes. It is heartening to see that the chapter on fundamental rights confirms some special rights on scheduled tribes. We may see some of the more important of these rights hereunder. Article 14 of the Constitution provides that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. This implies that not only will the law treat all persons equally, but there is also an obligation upon the government to ensure that all persons are on an equal footing before the law. This requirement of ensuring everyone is on an equal footing before the law has been interpreted as directing the government to take steps to actively improve the lot of the scheduled tribes inter alia. Within the provision for non-discrimination by the state under Article 15, there is a provision that the state may make special provisions for the scheduled tribes. This clause has been the basis for reservations for scheduled tribes in various educational institutions, etc. Non-discrimination in the context of public employment is covered within Article 16 of the Constitution. Within a general principle of non-discrimination is located an opportunity to make special provisions in favour of the scheduled tribes. It is to be noted that these special provisions are not to be seen as exceptions to the non-discrimination principle, but they are seen as being integral to the non-discrimination principle. This means that the system of appointment of persons to public offices will be truly non-discriminatory only when special provisions are made in favour of those who would not otherwise stand on an equal footing, and the importance of righting historical wrongs is highlighted thereby. The practice of untouchability was the underlying reason for the exploitation of the tribal peoples. It adversely affected not only the immediate victims, but the country as a whole. The Constitution rightly sought to unequivocally abolish it and prohibit the practice thereof, vide Article 17 of the Constitution. Article 19 of the Constitution is a very important provision that gives us the 6 fundamental freedoms. These freedoms are not without restrictions. The special sensitivities of tribal people have been taken into account here, in that one of the grounds for restricting the freedom of movement and the freedom of residence of the citizens is the welfare of the scheduled tribes. While a significant chunk of the scheduled tribes today belong to religions other than Hinduism, and they were originally categorized as being part of the Hindu religion. However, the religious practices of a significant proportion of the tribal peoples were such that they usually did not entail access to temples, and the temple entry movement, which was so important in the history of Dalit emancipation in India, does not hold as much significance for the tribal peoples. However, the provisions of Article 25 of the Constitution open the doors of all Hindu religious establishments to the tribals also, and it is important for a large number of members of scheduled tribes also. The directive principles of state policy guide the state in the direction it should take and the goals it should achieve in its march to development. Here, Article 46 provides that the state shall endeavour to ensure the economic and social development of the scheduled tribes. Taking into consideration the need to pay special attention to the welfare of the scheduled tribes, Article 164 makes it mandatory for some states such as Chhattisgarh, Jharkhand and Orissa to have a minister for tribal welfare. Seats are reserved for members of the scheduled tribes in the House of People of the Parliament, that is the Lok Sabha, vide Article 330 of the Constitution. Taking into consideration the special circumstances of the scheduled tribes of Assam, the provision that has been made for their representation is slightly different from the rest. Seats are reserved for members of the scheduled tribes in the lower house of the state legislatures by the effect of Article 332 of the Constitution of India. Assam is treated a little differently, as is the case with Article 330. Though the 73rd and 74th Amendment have brought about a sea change in the area of local self-government in India, it is to be remembered that the benefits of these constitutional amendments were not available to a large number of tribal people, as the effect of these amendments were not initially extended to the scheduled and tribal areas. This was taking into account the special administrative system that was in operation in these areas in the form of councils. However, the Panchayat Extension to Scheduled Areas Act PESA has remedied this to an extent, though it is yet to be brought to implementation in several areas. In the areas where the Panchayati Raj system is in operation, it is mandatory to reserve some seats for the scheduled tribes, and the number of seats reserved should be in proportion to the percentage of scheduled tribes in the area. This is through the effect of Articles 243D and 243T of the Constitution of India. We will now take a look at the various functions to be performed by the National Commission for the Scheduled Tribes. First, to investigate and monitor all matters relating to the safeguards provided for the scheduled tribes under this Constitution, that is the Constitution of India, or under any other law for the time being in force or under any order of the government, and to evaluate the working of such safeguards. Second, to inquire into specific complaints with respect to the deprivation of rights and safeguards of the scheduled tribes. Thirdly, to participate and advise on the planning processes of socio-economic development of the scheduled tribes and to evaluate the progress of their development under the Union and any state. Fourthly, to present to the President annually and at such other times as the Commission may deem fit reports upon the working of those safeguards. Fifthly, to make in such reports recommendations as to the measures that should be taken by the Union or any state for the effective implementation of those safeguards and other measures for the protection, welfare and socio-economic development of the scheduled tribes. And sixthly, to discharge such other functions in relation to the protection, welfare and development and advancement of the scheduled tribes as the President may subject to the provisions of any law made by the Parliament by rules specify. As you can see, a very wide sweep of duties have been put upon the National Commission for the tribes. The commission is headed by a chairperson, and these functions are carried out by other functionaries working under him. Now, special legislations have been enacted to safeguard the interests of the scheduled tribes. The most important among them is the Prevention of Atrocities Act. Physical and mental abuse, humiliation are only some of the problems that members of the scheduled tribes have to face almost on a day-to-day basis. It is in recognition of this horrendous state of affairs that the Prevention of Atrocities Act has been passed. This legislation works in two ways. Firstly, there are some acts which are not otherwise criminal offences, but since they are used to humiliate or denigrate a member of the scheduled tribe, they are classified as offences when they are used against a member of the scheduled tribes. Some of the offences which are sought to be punished are: first, compelling a scheduled tribe member to eat or drink obnoxious substances. Second, wrongfully occupying the land of a member of the scheduled tribe, dispossessing a member of the scheduled tribe from his land. Third, forcing a member of the scheduled tribe not to vote or to vote in a particular manner. Fourth, insulting or intimidating a member of the scheduled tribe with a view to humiliate him in public. Fifth, to deny a member of the scheduled tribe a customary rite of passage or prevent him from having access to a place of public resort. Several other acts which are offences within the scope of the Indian Penal Code are given an enhanced punishment when such offences are directed against members of the scheduled tribes. To give a few examples, mischief by fire or arson. Secondly, fabricating false evidence. Another hurdle faced by the members of the scheduled tribes in fighting these atrocities against them is that they have to navigate the legal system, which can become cumbersome and is fraught with delays. For this purpose, the legislation also provides for special courts which are meant to be dedicated to cases that arise in this regard. Another legislation that is very important in this regard is the Protection of Civil Rights Act. Originally called the Untouchability Act, this is a statute which may be said to be operationalizing the idea of Article 17 of the Constitution, which has been discussed previously. This legislation provides for punishment of persons who prevents another of the same religion any place of public worship which is open to other person professing the same religion on the grounds of untouchability, and the same is provided for under section 3. The same provision also makes it a punishable offence to prevent from worshipping or offering prayers or performing any religious service in any place of public worship, or bathing in or using the waters of any sacred tank, well, spring or watercourse such as river or lake, or bathing ghat at any ghat of such tank, watercourse, river or lake, in the same manner and to the same extent as is permissible to the other persons professing the same religion. Where we have seen that this statute operationalizes Article 17, we may see that in its provisions it also operationalizes Article 15, which says, no citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them, would be subject to any disability, liability, restriction, or condition with regard to a. access to shops, public restaurants, hotels, and places of public entertainment, or b. the use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. Section 4, 5, 6 and 7 of the Protection of Civil Rights Act bring Article 15 to implementation, which is achieved by making it a penal offence to not follow this aspect of Article 15. The main national level legislations notwithstanding, the uplift of the scheduled tribes is a fight that has to be fought on several fronts. Apart from these efforts and the efforts taken by the tribal welfare ministries in various states, we also need to ensure that the tribal people get access to modern ways of life. This does not mean that the duty of the government towards the goal of upliftment of scheduled tribes is over. Far from it. This duty has only increased with the new challenges that development has brought for the scheduled tribes. The loss of forests has and the unsustainability of traditional modes of cultivation have forced scheduled tribes into unfamiliar territory. The stance adopted by eco-conservation, which forced tribal people out of their homelands in the forests in many instances, have also presented new challenges for the government to now try and overcome. The hunt for mineral resources has also affected the tribal peoples to a great extent. Instances of tribal peoples being displaced to facilitate extraction of minerals are numerous. The Naxal movement and the government retaliation have meant displacement and uncertainty to a lot of tribal peoples. While the goal of a development is all well and good, it should be kept in mind that this development cannot come at the cost of tribal welfare. We have looked at a few important legislations dealing with the welfare of tribal people. We have also looked at the important constitutional provisions which guarantee equality to tribal population. However, all of us are aware of the menace of Naxalism which clouds the Indian democratic state today. It is often argued that Naxalism is directly linked to the lack of development activities relating to tribals. It is often said that Naxalism could only grow and fester because the tribal growth was neglected for a very, very long time. Today, there exists a Naxal corridor, as they call it, from Kathmandu to Tirupati, though it is not continuous, and though the Indian government is putting up a brave front and has succeeded in curbing and stopping the menace of Naxalism to a large extent, it still continues to be a major problem in various parts of country. It is also to be noted that this fight with Naxals has its theatre in the most tribal dense areas of India. In this fight, the fodder are often the tribals from both sides, be it the government or the Naxals. The ultimate losers are always the tribal people, whoever be the beneficiary of the Naxal operations. The question which is posed to us is, why is it that the Naxalites were able to lure the tribals into their fold? Or more importantly, why is it that the government of India could not establish its credibility with the tribals enough to ensure that they do not side with insurgent forces against it? The answer is simple. From the British times, the tribals have looked at governments and the forest departments as not institutions which seek to help them, but institutions which seek to oppress them. Be it taking away the rights of minor forest producers, be it making them move out of their homelands for setting up conservation parks, and many such other activities ultimately disrupt the tribal way of life. While it might not be the best option to keep tribals in a museum-like state and not let them come out of it, not expose them to what modern times have to offer, it is also true that the tribal ways of life need to be conserved. Not only do the tribal ways of life need to be conserved, they also need to be promoted. The issue of tribal welfare and tribal living is an issue of utmost importance in today's world. We have seen that Naxalism was called the greatest internal threat to India by none other than the Prime Minister himself. This Naxalism has come about mostly because of the neglect of tribals by Indian society and the Indian state. It is about time that we not only make empty promises to tribal people, but actually integrate them into the mainstream society. It needs to be stated here that certain important steps have been taken in this regard recently. More consultations are being held with tribals when lands are acquired. Under the PESA, about which we have talked previously, they are given right to collect minor forest produce. They are also given a right to decide on the way development activities are to be conducted in the areas which they inhabit. Overall, it can be said that tribal populations, which have always formed an extremely important part of Indian society, need to be brought into the fold again. They should not feel alienated. The tribals are and have always been a part of Indian society. Be it the Bhils, be it the Gonds, be it the Khonds, they have always formed an integral part of not only Indian society, but also Indian economic milieu. As a matter of fact, they were major forces also in Indian political milieu, as can be seen in the Munda rebellion, as can be seen in other tribal rebellions against the British occupation of tribal lands and imposition of forest rules against them. It is very clear that tribals have always formed a part of the Indian rubric. It is not becoming of us today to see them rising against the Indian democratically elected governments. And far more importantly, it is not becoming of us to let any particular section, be it Naxals or anybody else, to allow them to continue to engender a dislike of the Indian state in their minds, because the tribals are an integral part of Indian society.